He's a founding member of Seiden Schein. He's currently the managing director and he's recognized expert in inclusionary housing, tax incentives, affordable housing, as well as co-op and condominium laws. One of the few attorneys whose expertise extends to many areas of practice. Jason is a partner in the firm as well, and he's the group leader in the firm's real estate tax incentives benefits group. He represents developers in a wide variety of real estate tax benefit matters, including 421A, 420C, 420A, and also has extensive knowledge regarding minority and women-owned business, as well as ICAP and equal employment and payroll reporting regulations. So we're very happy to have two here. With that, I'll turn it over to our friend Seiden Schein.
Thank you, everyone. First, I want to thank Joe and John for putting this event together. I've known them for many, many years since they started on New York, and I've stuck with them. It's a matter of personal relationship. That's what matters to me. I could use any large title underwriter, but I want to call the people I know when I have a title problem, and I know it gets done. And that's the way we operate. That's the way our firm operates. We have long-term clients in our firm. People from Artemis are here, have a long-term relationship. We have a long-term relationship. My friend Justin Alganian is here. Happy that I began working for Rockrose as an attorney about the time he was born. And that's a lot of years. I'm not going to tell you how many years, but it's a lot. Just a matter of personal relationship. Okay. The 421A statute expired 2 years ago. And as we all know, construction starts of multifamily housing went straight down. The only thing that was happening was either condominium development or government subsidized jobs that would get 420C or Article 11. Privately financed rental just went straight down to the point that this year, almost nothing was happening. Governor Hochul saw that there was a big problem, and she pushed hard. She pushed hard last year and lost. This year, she came out with guidance and other things that we're going to talk about, but appeals had to be made. There was a special interest group that wanted uncaused eviction, and their representatives were not going to vote for it without getting. There was also a big push from the labor union. Labor was not happy with what they had under the old 421A of only requiring minimum wage or minimum average wage with 300 units or more in certain locations. And they had a lot of politicians on their side. You've heard the phrase, a camel is a horse created by a committee. And that's kind of what we have here. There was no economic analysis done of the various statutes as to what would the effect be of minimum wage on a 150 unit building. This was negotiated. A number was negotiated. So we don't really know exactly how this is all going to turn out because there's no data to support any of it. But we do know is we do have a program for new construction. We do have a 420 extension, and we do have a program to have a tax exemption for conversions of offices to residential, which is a great opportunity for everyone here. There are also legislation, which I'm going to talk about, which affects towns and municipalities outside of New York City. So that may be important to those who work outside of the city, and I'm going to talk a bit about it. But first, my partner, Jason, who is really the most knowledgeable guy I know on the subject, is going to talk about the new tax incentive program. Thank you, Alvin, and thank you, Joe, for that introduction. As you said, Alvin, one of the smartest attorneys that you know, and I'm here too. So let's get going. You all should have the printouts in front of you. We're going to start with probably the easiest one of the bunch, and that's the extension of time to complete under the 420A16 program, also known as Affordable New York. So this is for a project that vested under that old law, and originally you had to complete by June 15th of 2026. They've extended that deadline to June 15th of 2031. So you had then the time to complete construction if you satisfy two requirements. One is that you forego the 30% of your unit, that 130% AMI option, and you also have to file what's called a letter of intent with HPD. That letter of intent needs to be filed probably sometime soon. They're supposed to release a form within the next 2 weeks, and then you'll have 90 days to file that form. So for the most part, it's a pretty good deal for this extension of time to complete for those that need that additional time under the old program. Also, as part of the new package, there was the 421A replacement, which is Section 485, also called Affordable Neighborhood for New Yorkers. Similar to the Affordable New York Housing Program, there are different options with percentages of affordable units and the AMIs for those affordable units. In this case, though, those options are entirely dependent upon the size of the project and its location. Unlike the previous program where you could possibly have a choice as to how many affordable units you would have and what those AMIs were, the project have a set number based on your location and the units. There's no ability to opt in from Affordable New York to this program. So if you vested under the old program, you're stuck with that one. If you didn't, you'll have this program. The big kicker here is the expanded applicability of the minimum wage for construction workers. So that's really the biggest difference between these two programs. In this case, though, the affordable units will also be permanently affordable and rate stabilized, similar to what we see in the inclusionary housing program. Market rate units here are permanently exempt from stabilization right off the bat. There's no kind of fumbling around with trying to hit a high rent threshold that we had under the Affordable New York fully. The next page that I have in this summary is a chart of the various options, how much affordability is required, what AMIs are required. I'm not going to go through each different option, but you'll see it ranges from 20 to 25%, from 80% of AMI to 60% of AMI, with varying levels of the benefit. For the most part, from 35 years up to 40 years. Really, two differences that I do want to highlight, and that's for very small rental projects where you actually don't need to provide any affordable housing, 50% of your units rent stabilized. That being said, it's only available for certain projects, small projects, 6 to 10 units outside of Manhattan, and with zoning residential floor area of less than 12,500 square feet. Also, one home ownership option, as there was under the previous program. Here, they've made a slight tweak, which I think makes it a little bit better, in that under the previous program, you had to have an average AMI of $65,000 or less in order to be eligible. Here, they've changed it to a square footage requirement. So an average assessment of $89 per square foot, which makes it easier for a larger apartment to also be eligible. Still, it's going to be difficult to be eligible. I don't think high rent areas would be eligible there, but at least it provides a little bit more applicability. And as far as important eligibility criteria, I'm just going to hit the highlights right now. That's commencement after June 15th of 2022, when the previous program expired. You'd have to commence here before June 15th of 2034 and complete construction by June 15th of 2038. Here, there's also an MWBE requirement, so there will be some sort of minority women-owned business enterprise requirement. The statute only calls for 25%. They don't really say how you achieve that. You're not going to need to ensure that 25% of your contract is spent on MWBEs, but what satisfies the requirement if you don't have it? Generally speaking, what we've seen in the program, if you don't hit that mark, the agency will want to see what effort you made. The solicitation you did will kind of correspond, going back and forth, to prove that you made a good faith effort to hire MW. There's either a proportionality test that your affordable unit make has to be proportional to your market rate unit make, or at least 50% of your affordable unit are two bedrooms and no more than 25% of studios. Keep in mind that the prevailing wage for building service employee still applies under. Also, as most of you know, you can be eligible for 45X, like 421A before that, and have up to 12% of the project be commercial, community facility, or accessory space. So if you do have a significant commercial component in your building, still may be 45X eligible. If you have too much commercial space, keep in mind that an ICAP may be possible for the project. The ICAP statute right now expires in April, although a bill to extend the ICAP for another 5 years was just introduced in the state legislature. So hopefully we'll have an extension of the ICAP statute as well. And final eligibility thing to be aware of is the replacement ratio. If you are looking to develop a site that currently has a residential building on it, you must replace every residential unit on that site with an affordable unit in your new building. So a lot of times, if you have a site that has a decent sized building on there, it may result in more affordable units than you might otherwise think you would need. It may be more than the 20 to 25%. And that's the general overview of 45X. I'll quickly go to what is Section 457M, and that's the conversion program. It's for any project that commenced December 1st, 2023, and complete by December 31st, 2039. So commitment in this instance is the receipt of a permit that would require a new certificate of occupancy. Here, they want 25% of the units to be affordable at an average AMI of 80%, with at least 5% of the units affordable at 40% of AMI. Pre-existing building that you're converting must be at least 90% non-residential. Like all the other programs now, affordable units will be permanently affordable and rent stabilized. Market rate units are exempt, and the benefits are based upon when you get a permit and where your project is located. So I also included a chart here which shows that those projects in Manhattan, South and 96th Street are going to have better benefits than those north of that or in the outer boroughs. And for every 2 years that goes by without getting a permit, you're going to lose 5 years of benefit. So those projects that get a permit to convert by June of 2026 will get a 35-year benefit. And that is where I'm ending on my part of the presentation. Obviously, we'll be here afterwards for any questions that people might have. But now I'm going to hand it over back to Alvin to discuss some of the statewide benefit programs that were introduced, as well as good policy. So, 421 is not bad. There are two new statutes that come with 421 before them. One is called 421P. Another one called 421PP. They don't apply in New York City. They apply everywhere else in the state. However, they only apply in any particular county or municipality if it's adopted. In other words, if the county or the town doesn't want it, it's not. That's what we all know. There are issues in many counties about multiple dwellings, about affordable housing. This is Governor Hochul's attempt to try to facilitate the construction of both mixed income housing and 100% affordable. Which, similar to the new statute that we're talking about, require 25% affordability. You get a 25-year post-construction action plus a 3-year exemption during construction. It's a good exemption. It starts at 96% over the many towns and declines 4% a year. Again, you only get it if the town or county adopts it. And you might say, like, why should anybody bother? Because they could get an IDA benefit, very popular upstate, where IDAs or industrial development agencies will give exemptions to multifamily development if it's happening. This is really good for a small project. Someone wants to go to an IDA, usually has a big project, costs money to go through the IDA process, a lot of fees involved. This is a much easier way that does not involve bureaucracy. One issue here, which I think is going to be dead in the water for most projects, is that prevailing wages required for any development over 30 units, which to me means this is only going to work for jobs that are under 30 units. Small jobs, that's what this program is perfect for. There's also a 421PP statute, which is similar, except it's for 100% affordability. The affordability would be between 60 and 80% weighted average. You know, AMI higher than 100%. The difference is the exemption period is longer, and there's no prevailing wage requirement. This could be very helpful for affordable projects that are going to be built outside New York City, assuming they can get through the town subdivision process and all the other things that hold up the creation of affordable housing. I spent part of my time in a small town called Southold, which is on the North Fork of Long Island, which has basically zero affordable housing and a huge need for affordable housing. I've been speaking with the town board and planning commission in town to adopt this law, and the results are very positive. I think they see the need to have something like this that could get affordable housing down. So I'm hoping that something will happen in Southold and other towns that do not have much affordable housing. The final feature of this year's program was good cause eviction. Again, this is heavily negotiated. It's far different than the initial proposal. The question, what does it apply to? It doesn't apply to rentals of co-ops or condos. It doesn't apply to rental of a building 10 units or less. It doesn't apply to a building that was built since 2009 for a 30-year period. So all of you who are building new buildings don't have to worry about good cause eviction. It's not going to come into play for a 30-year period, assuming that's still here. So what it really applies to are older buildings that became decontrolled in whole or in part. That's really what it's addressing. So what is it? There are very limited reasons that you cannot give a tenant a renewal lien. Basically, somebody was not paying, or it's a difficult tenant, you don't want to give them a renewal lien, but they have the right to challenge that in court. So you can have a court proceeding as to whether or not you have to give the person a renewal. And then rent increases are limited to the lesser of 10% per year, or 5% plus the rate of inflation. Rate of inflation is about 3.4% last year. So at the moment, the maximum permissible rent increase for a non-regulated building, the maximum increase would be 8.4% right now. And by the way, that does not apply to the neglect departments either. DHR does not have jurisdiction of this. There's no regulatory agency that's going to be monitoring them. To basically going to be put to the tenant for it to determine whether or not a tenant was unlawfully evicted or had an unlawful notice of eviction. How it plays out, we don't really know. The one thing to know is the lease of every dwelling, every apartment, every house is supposed to have a rider in it that says that you are either subject to good cause eviction or you're not subject to cause eviction, which means that everyone here who has rental units is going to have to get a form together to slap onto their list. That's another form, one more form, and that's about it. We're going to open the floor to questions. Jason, you want to come back up? Anyone have any questions? What makes the locality choose to invent the rate key for municipalities to adopt it would be to encourage the production of multifamily, which is sadly lacking throughout the state in areas outside the city. That's the purpose. You got to tax break, build multifamily with 25%. That's the idea. But to me, by putting prevailing wage requirement there, you're going to limit it to small building. And I think that's what we'll see. It's under 30 units. I think one last way. You have a building like on the popular walk on, it's occupied by an apartment or remarket, and I want to demolish it. And I get back to the apartment to just do the new lease. And we did the very brief and how can that be rebutted? So that's a very good question. There is an exception on the cause of eviction if you plan to demolish the building and build a new building. However, that's all the statute says. There are no standards, there's no procedure. It's not like the rent stabilization code that has several pages of procedure for eviction. This is something that's going to have to be litigated in the future as to whether or not an eviction is good faith, whether the developer has the capability of building something new, but it is in the statute. But how it plays out, nobody. Thank you, Alvin and Jason, again for a very informative program on a really new and exciting property and DHC law.